You are watching Morning Musings with Reinhard von Hennigs, chairman and founder of Bridge House Law in Charlotte, North Carolina.
Who is allowed to use a yellow circle in a square blue background? Hello, this is Reinhard von Hennigs, and maybe I should specify the question. Who is allowed to use the yellow circle in the United Kingdom if it is in a square blue background? The quick answer is discounter Lidl won a trademark battle against UK's biggest supermarket chain, Tesco. 20–30% market share of Tesco against 7 or 8 on Lidl, depending on which of the studies you believe. So it was almost like a David versus Goliath claim. What happened? The High Court ruled that Tesco's club card is a copy of Lidl's logo, which both use a yellow circle on a square blue background. Lidl said Tesco had infringed the copyright, and therefore Tesco took an unfair advantage of the reputation from Lidl for value. Tesco, of course, said it was disappointed and they want to appeal. So what is this all about? Lidl started in the year 2020 the lawsuit shortly after Tesco used this logo to promote its club card discount scheme. They argued that Tesco deliberately copied the logo to deceive customers. Those logo circles on different backgrounds could only mean that it was a Lidl and therefore prices were compatible and therefore they should go to Tesco. Judge Joanna Smith said in a written ruling which was issued this week that Tesco had an unfair approach. They took an unfair advantage of a distinctive reputation, which is the reputation for low prices. However, she also said that Tesco had not been seeking to deliberately ride on the coattails of Lidl's reputation. This is what Lidl had said. It seems to be now that the real deeper argument is who owns the trademark and what does it mean? The dispute about the specific logo, particular a yellow circle on a square blue background, is, well, maybe it is too confusing, maybe it is not. But if you are in the same industry of retail grocery stores, discount grocery stores, it is certainly there to cause confusion, which is the ongoing argument in any trademark disputes. And if there's confusion between customers, it could harm Lidl's reputation and then Lidl's business. The case went all the way up to London's High Court, which ultimately ruled in favor of Lidl, finding that Tesco's use was a creator of confusion. So therefore, Tesco was now ordered to stop. Those disputes about trademarks are not uncommon. Companies must protect their intellectual property rights, and they must ensure that their trademarks are not infringed upon by competitors. Those disputes typically arise about a real tight market. So what we have here is a battle between two supermarket chains. The real consequence or the real conclusion I always see in those trademark arguments is fight early, fight hard if your trademark wants to survive, because otherwise the trademark may evaporate. While the court ruled now in Lidl's favor, it is still not completely over, and we'll wait whether we have an appeal, a settlement, or whatever comes next. There are, however, several lessons learned. Number one, be careful when creating a logo or when using a trademark. Companies need to ensure that their trademark is unique and not likely to be confused with a competitor. Number two, conduct a trademark search before adopting a trademark. Let's check whether you really have that logo or whether nobody else has any rights. Number three, take legal action to protect your property rights. So if you believe that somebody infringes with your copyright, with your property rights, with your trademarks, fight hard. Number 4, be prepared that it could be costly. Legal action, not only in the United States, the United Kingdom, or whatever it is, are costly. So you need to weigh out your potential risks and your potential costs with your potential benefit, which is to secure your intellectual property rights. And lastly, if you are a company out in the market, respect the other intellectual property rights of your competitors or of other companies. If you're out to make sure that you are not using anybody else's copyright, you then avoid pricey and costly legal disputes. So here we are talking about a European company, Lidl, the German grocery, probably through their UK subsidiary in a post-Brexit United Kingdom. Are trademarks safe after the Brexit? Lidl remains all of its trademark rights in the UK because the trademarks are not governed by the Brexit or by the European Union laws. They are governed by international treaties, such as the Paris Convention and the Madrid Protocol. Both of them are not affected by the Brexit. Furthermore, the United Kingdom and the European Union have argued to recognize each other's trademarks and to provide for protection of the trademarks in their respective territories. Here, in this case, it means that Lidl's trademark was registered in the European Union before the Brexit still continues to be protected in the UK. In addition, everybody, including Lidl, is free to register new trademarks through the UK Intellectual Property Office, UKIPO, which is now independent from the European Union filing systems in Alicante. Overall, if you're a foreign trademark owner and you're concerned about your rights in the UK, your rights remain largely unchanged after the Brexit, and you can continue to protect your property rights in the UK as well as in any other country.
Whether you're a private citizen, an international business leader, or simply someone eager to stay on top of the latest news, this book is a great way to get caught up on the most recent developments in the worlds of international business, tax, politics, and social affairs. Go to morningmusings.com and order your copy today.
Thank you for joining us today. If you would like more information about British House Law, please visit our website at bridgehouse.law. Before you go, make sure to like this video and subscribe to the channel for more up-to-date content. British House Law, business-minded, client-focused.